Hi, I'm Kevin.
Hi, I'm Yang Shuh. My friends call me Gui, and I am a third-year associate at the law firm Screen, in the intellectual property department specifically.
So, in today's episode, we have Gui here. As previously said, he is a lawyer who specializes in intellectual property, to discuss on the topic of what exactly does an intellectual property lawyer do. So, as an introduction, could you tell us exactly how did you, as a law graduate, ended up as someone who practices intellectual property?
Sure. Ever since I was a kid, I've always had an immense passion for film, music, video games, the entertainment industry generally. And so after I finished my SPM, when it was time to decide on an actual career, figured that if I studied law and I studied intellectual property, I'd be able to combine both my passion as well as my career, sort of a best of both worlds basically. So from the get-go, when I was studying in A-levels, the plan was always to get into intellectual property. Yeah, so at university, during my degree, I chose intellectual property law as an elective. Even at bar school as well, I chose intellectual property law as an elective. When I applied for pupillage here at Screen, in my cover letter, I stated specifically that I wanted to be attached to the intellectual property department, and I was. And here I am now, retained and practicing as an intellectual property lawyer.
Oh, wow. So, before we go into why are you so appealed to intellectual property, could you give us an illustration of what exactly is intellectual property in the first place?
Yeah, sure. So the funny thing is, a lot of times when I tell, especially my relatives, my aunts, my uncles, that I am practicing as an intellectual property lawyer, the first thing they say is, "Oh, property, oh, so that means can you help me review this SPA? I'm buying this house, can you help me review the contract?" And so they always seem to catch on to the word property, missing out the word intellectual before it. So intellectual property is basically a form of proprietary rights afforded over abstract, intangible creations of the mind, intellectual property, literally, as the word says. So there are a few main types of intellectual property. For example, trademarks. So that's a protection afforded for brands, logos like your Nikes, your Adidas, your Reeboks. So these are all brand logos that are protected under trademarks. There's copyright, which is a protection for works. So but these works are more like novels, songs, films, arts, paintings. So all of these are protected under copyright. And lastly, well, not lastly, but we also have patents, which is a protection afforded for inventions, novel, new inventions. For example, currently the biggest thing right now is 5G. So companies are all trying to create and invent 5G technologies. And so if you have a patent for that, you secure your rights in that. And the true line among all of these intellectual property rights is that they secure your right to use this, whether it's a trademark or a copyright in a book, and it prevents others from copying or reproducing your creation, your asset, without your permission.
That's really interesting. Then, how exactly does this concept apply to Malaysian context? And what's the work that revolve around it, like the contentious and the non-contentious part, and usually how does it go to the court then?
Right, okay. So I guess this is where if you are an IP practitioner, you could be a bit more different from other lawyers practicing other areas of law, because usually as a lawyer you would think, alright, you're either the type that goes to court, litigation lawyer, or maybe you are a corporate lawyer, meaning the type that generally advises companies on M&As, on acquisitions, IPOs, so the type that doesn't go to court, or conveyancing lawyers who also don't go to court. But IP practitioners, they are a kind of a special breed in that they are a combination of litigation and corporate, because there are two main aspects to being an IP practitioner. The first aspect is registration and prosecution. So this side of the work is basically where you're applying to register the intellectual property right. So applying to register a trademark, applying to register a patent and advising the clients on how to go about that. The other aspect is basically litigation and enforcement. So this is where, like you mentioned just now, contentious disputes, where you go to court, fight out battles related to IP subject matters specifically. But the other side of enforcement is, so that's civil enforcement, but the other side of enforcement is criminal or administrative enforcement. So as an alternative to going to courts, this applies specifically for counterfeit goods most of the time, but as an alternative to going to court and suing someone, which can be very lengthy and cost consuming, what we have here available in Malaysia, and actually most jurisdictions around the world, is you can complain to the regulatory authority. Here it's the Ministry of Domestic Trade. So let's say a brand owner comes across a counterfeiter selling counterfeit shoes, counterfeit bags bearing their brand, right? So what they can do is come to us IP practitioners. We, on behalf of the brand owner, will lodge a complaint with the Ministry of Domestic Trade to organize what's called a raid, an enforcement raid. And so during the enforcement raid, what happens is the lawyers, on behalf of the clients, along with a team of Ministry of Domestic Trade officers, will go to whether it's a store premise, warehouse, factory of the infringer, pay them a visit, and basically seize and confiscate all of the counterfeit goods there on site. So yeah, it's not as dramatic as you would imagine. It's not like there's a SWAT team, say, with machine guns or anything, but basically, the lawyers will be dressed in plain clothes. You'll be going there undercover, basically, until when you have to seize and confiscate the goods. Yeah. So that's sort of like the rough summary of the contentious versus non-contentious side of being an IP practitioner. And so the thing is, it depends on the firm really. Some firms, you as an IP practitioner, you have to do both registration, prosecution, as well as litigation and enforcement. But other firms, like Screen for example, there's a clear division between these two aspects. So I am actually in the IP litigation team specifically. So my main portfolio relates to contentious disputes concerning IP subject matters, whereas there's a different team, my colleagues, they handle non-contentious IP registrations exclusively. So there are two sides. Some firms, you're kind of like you have to be a master at all trades. For us, we get to specialize more in depth versus between contentious versus non-contentious.
That's definitely interesting.
Right.
Then, like, going back to the first question, then what exactly of IP that appeals to you so much then?
Right. I guess it's because IP, it's something that we encounter on our daily lives, although most people don't really realize it. When you put on your Nike shoes, your Nike sneakers, there is the Nike logo on it. That's protected under trademark. When you listen to a song on the radio, the song is protected by copyright. When you watch a film, that's protected by copyright. When you're using your phone, like this phone right now, probably has around 100 different patents at least protecting the technologies inside it, from the software to the processors to the chips and components inside. So IP, it is something that's, although it is intangible, it's an intangible asset, but we do interact with it in a very tangible way in our daily lives. So it's just something that's much more relatable, something much more easy to grasp, at least for me personally, as compared to like other areas of law. And as I mentioned, the whole reason why I got into intellectual property law was because of my passion and keen interest in the entertainment industry. And so as an IP practitioner, you are some cases you do deal with disputes over royalty payments with regards to maybe a novel or a song. Sometimes you have to deal with disputes between similarities between a brand logo and another brand's logo, and how there's a conflict in that sense. So it's just something that's you can really relate to on a daily basis.
I see. From this is like, as you already said, you're someone who practices the litigation side of the IP. So how does a day at work sounds like then?
Alright, quite boring actually. Most of the time when I go into the office, the first thing I do is, of course, check my emails, reply whatever I did not reply to the day before. And a lot of times it is just drafting, doing a lot of drafting, whether it's court papers mainly, affidavits, legal submissions, cause papers, statement of claims and all that. And together with the drafting, a lot of it is research. I spend a lot of my time, whether it's on online case databases like LexisNexis, CLJ, and just pouring through cases, trying to look for authorities that support what I'm trying to say. And I'd say I go to court on average about maybe once every 2 weeks or so. For case managements, I have a hearing maybe once every month or once in every 2 months or so. So that's basically it. It's not very glamorous or exciting in that way.
It's okay lah. It's like, as long as you like what you like to do, then it can.
Yeah. Well, though I do hate doing all the admin stuff. Like actually, that's another side of practice that a lot of people don't tell you. Is that oftentimes you have to do a lot of administrative work. Basically, just processing documents, going through emails, and just replying to clients, and also just sorting out your files, making sure that everything is in order, that you have the documents you need. A lot of this kind of like very tedious, not exciting work.
Because it's like part and parcel lah, nothing to do about
exactly.
Speaking of this, like, then what have been the highlights or milestones of your career then?
I guess, well, every first that I've had definitely has been a milestone. As I mentioned, I'm just a third year associate, so I'm very, very young, very, very fresh in my career. So I don't have very amazing milestones as compared to others, but the first time I appeared in the Court of Appeal, the first time I appeared in the federal court, even the first time when I drafted my own set of submissions, sent it to my senior. It was then approved, filed in court, and we won the case based on the submissions that I drafted. Although I wasn't the one at the hearing presenting the submissions and everything, but just knowing that the legwork, the basic groundwork, I had a help in contributing to it. That was something that I was quite proud of. And I guess maybe a more interesting highlight was this one case that we had. I was acting as the junior counsel. Lead counsel was my colleague Joshua. And basically our client had been charged with selling counterfeit products. The prosecution, they were charging our client for selling counterfeit goods, but our client's case was that actually, no, these are genuine products, but they were just imported from overseas and not bought from the local supplier, not sourced from the local supplier. So because of that, we had to travel overseas to meet the client supplier. Yes, it was in Hong Kong actually. And the thing is, I had to go alone. My colleague Joshua wasn't available, but I was still just the junior on the file. I wasn't the main person on the file. Nonetheless, had to go to Hong Kong for 3 days together with the clients. Went to meet with the supplier in Hong Kong, interviewed him, gathered evidence. We had to look and examine the product itself as well to see exactly how can we show that it's genuine. Looked at the licenses, and the thing is that I can barely speak Cantonese. So I'm from Penang actually, so Hokkien is my mother tongue and everything. So it was very difficult for me to follow the conversation, and I had to beforehand, before even getting on the flight, check what is intellectual property not intellectual property, but like trademark. What is trademark in Cantonese? And then on the flight over, I had to revise, do homework basically, to go through the translations to make sure that I wouldn't make a fool of myself in front of the client. So that was a fun and interesting experience.
That sounds like something like you see in movies where you have to go to overseas to do investigations.
Yes, but I have to caveat that it's the only file so far that I've ever had to do something like this. So please don't think that flying jet setting is something often that occurs if you're an IP practitioner. No, it's not. This was a very rare exception.
Okay lah, it's like something to talk about when people ask you what's interesting about your work.
Yeah, exactly.
So like as you already mentioned, like this is currently only your third year of practice. So what's your current definition of success then?
Well, I guess for me personally, it would be getting recognized as a notable IP practitioner. I know they always say, fame and glory shouldn't be what you prioritize, but at least for me, I think if I have that sort of validation, that sort of recognition, it at least makes me feel like I am doing something good, that I am making a difference, to be able to be recognized, whether not even among clients, but among my peers in the industry. That if people were to ask someone else in a different firm, who are the notable IP practitioners that you know, is there anyone that you recommend? And if my name is on that list, I say that is something that I'll be very proud of and would like to be able to achieve one day.
That's really interesting. How's your personal approach to that then? Like what do you do specifically to try to achieve that?
Okay. I don't know if I'm on track yet, so I don't know if what I'm doing will actually help me achieve that yet. But I guess definitely you have to put in hard work and churn out good work for clients. And I think another thing that people don't really realize is you have to really treat everyone with respect, with humility. Not just to the judges, not just to your clients, but even to your opponents that you're working on the case. Treating them with respect, with courtesy, that will take you far ahead. There's no point in making enemies left, right, and center. And I think when you give respect and you earn back that kind of respect, I think that's when you will be recognized as someone worthy of being recognized as an IP practitioner. And of course, winning a lot of cases, but win or lose, that really depends on the case that you get, depends on the judge. You don't really have full control over that. I guess networking.
That's a really good message. So as moving on to our last and final question then, because you already told us you're already someone who was really keen on having good IP, what advice would you give them to aspiring law students and lawyers who are keen on practicing IP as well?
I guess one thing is to have a willingness to learn, and not just IP, the law itself, because, for example, if you're doing patents, patent, like I said, protects the invention, technology for that particular patent. So it can be a patent for a new type of drug, it can be a patent for a new process of manufacturing a certain item, it can be a patent for technology in like your iPhone. So you need to be able to have that kind of desire and diligence to learn not just the basic IP law, but also the underlying subject matter, the underlying topic, the underlying technology for your case file. Because again, going back to patents, if you are going to be cross-examining your opponent's expert witness on that area of industry, on that industry, you yourself as a cross-examiner, you have to be as familiar as, if not more familiar than the expert in that piece of technology. And so I say, read up, just read generally. Don't be so myopic in what you choose to read. And you have to, I guess, also, and I guess one other thing that I probably would have liked to hear as a student or as a law graduate was to have a personality and to not be afraid to voice my opinion offend anyone. But sometimes I think it is important to to be able to question and share our thoughts in a piece of work, because on the one hand it shows that you're actually interested, that you care about the file, that you care about the work, that you care about the case, that you have a sense of responsibility over it. And another side is that I think employers these days, they don't just want a mindless robot that just comes in and takes instructions, churns out instructions. They want someone who can show that you have something to contribute, that you're able to add value. So if in a case you have a chance to discuss something with your seniors, with the lead counsel, don't be afraid to chip in, don't be afraid to voice out your thoughts, even if it's in a room of 5-year, 10-year, 20-year lawyers in practice. You are just a 3-month-old pupil, but there are always fresh perspectives that you could share that maybe you notice that others don't. So don't be afraid to just have your voice heard.
That's really something people struggle with nowadays.
Definitely.
Alright, so that's the end of it. Thank you so much for joining us.
No problem. Most welcome.
Okay.
Alright.
Alright, that's it.
Alright.